Before we get into today's episode, a quick warning that it contains discussion of sexual violence. Listener discretion is advised. Hello and welcome to the Daily Aus. I'm Elliot, Lawry.
I'm Billi, FitzSimons.
Last week, a jury in Victoria found a man guilty of raping a woman twice in 2024. Despite this guilty verdict, a suppression order remains in place, meaning media outlets have been unable to publish his name. The case comes amid growing criticism of the widespread use of suppression orders in Victoria's court system. So in today's episode, we're going to break down what happened in this case, what exactly a suppression order is, and when and why a court would use one.
So, Elliot, we have seen this rape case unfold in Victoria over the last couple of weeks. And what has been so interesting about it is that there has been this suppression order, which has meant that the media is not able to name the man who has been found guilty of rape. For those who might have missed it, do you want to just take us through the elements of the case that are public?
Yes, so over the past few weeks, a jury in the County Court of Victoria heard the details of an incident that occurred in January last year. So it had a lot of moving parts, but sort of the top line details that we heard in the victim's testimony was that she was sleeping in a dark bedroom when a man, we'll call him Man A, snuck in, climbed into bed and penetrated her without consent. Now, she testified that Man A was pretending to be another man, who we'll call Man B, who she had actually had consensual sex with earlier in the evening. Man B had actually left the building in an Uber. However, despite it being dark, the woman said she knew that the man entering the bed was not Man B, and she recalls catching a glimpse of Man A as he dashed out of the room after the incident occurred. She then later identified Man A as the person whose house they'd been staying at, and the jury also heard how, in the days after, Man A actually doctored an Uber receipt to make it look like Man B was still in the house at the time that the incident occurred. So basically tried to say that he was the one entering the bed instead of Man A. Ultimately, Man A was found guilty on 2 counts of rape by a jury last Friday. Despite this, we, as a media company, are actually not allowed to say his name due to a court order that's still in place.
And this case has now received a lot of attention because Man A, who has been found guilty, has been referred to as the son of a high-profile family by other publications. And a lot of people have questioned why exactly his identity is still being protected following the guilty verdict. Do you want to walk us through the reasoning behind that?
Yeah, I've actually seen quite a lot of commentary, especially on social media, with people saying that the media is potentially being evasive by not saying his name. But the reason they're doing that is because the judge in this case issued something called a suppression order. And that order is very much still active.
I think we should pause and you should explain what exactly is a suppression order.
For sure. So a suppression order, sometimes you'll hear it called a gag order, is basically a direction by the court that makes it illegal to publish certain details about a case. Most commonly, this means hiding the identity of the victim or the alleged perpetrator, but it can also relate to other facts of the case, so not just identities. Now, there's a bunch of reasons why a judge might issue a suppression order. It could be because they think the public attention could affect the jury's decision. It could be because a person's safety might be jeopardized. So, if they know that someone is appearing in a case, someone might come after them. And more commonly, we're seeing an argument being raised by defendants that they need to have their names suppressed because it poses a risk to their mental health to have it out there in the public.
And a suppression order is a legal order. So media publications like us can't publish the name because otherwise there are consequences. What are the consequences?
So the penalties differ between the states, but generally speaking, if the media does not abide by the rules set out in a suppression order, they could be fined more than $500,000. So it's not nothing. And we've actually seen it happen before. I want you to cast your mind back to 2018 when Cardinal George Pell was facing charges of child sexual abuse. Do you remember this case?
I do. I was working in media at the time. It was an absolutely massive day.
Well, you'll remember at the time a suppression order was placed on Pell's identity because he was actually set to face a second trial over separate allegations. And the reasoning there was that the court didn't want the first case potentially influencing a jury in the second case. Now, at the time, Pell was one of the highest ranking officials globally in the Catholic Church. And when he was initially convicted, no Aussie publications could actually write about it.
And the key word there is no Aussie publications, because what was so interesting is that international publications could name him. So you could go onto the New York Times and you could see George Pell's name everywhere, and that was the same for all international publications, but you just couldn't go on any Aussie publication and see it. But it was so interesting because obviously because of the internet you could access the international ones and see it.
And you might remember in particular the Herald Sun, that's a newspaper down in Melbourne, they kind of pointed to this idea. So they completely blacked out the front page of their newspaper and they had censored in big white writing, and they kind of hinted to their readers that they could go find out the details of the case by going to international publications.
Yes. And then a lot of publications did actually get in trouble for that because they were inferring who it was by directing them to go find out who it was.
Hi there, my name's Emma. I'm the editor at the Daily Aus, just popping in to say hi and let you know that here at the Daily Aus, we are an independent media company who work to break down the news for young Aussies in a digestible and accessible way. If you like what you're watching and you like what we do, please hit the subscribe button. Now back to the video.
Exactly. And the courts ended up cracking down on all these publishers and they actually handed down fines of more than $1 million to at least 12 publications who kind of took this tactic of sending people to where the information was.
So interesting. And I think it is also worth pointing out that that story was one from Victoria, and the one that we are talking about today is also from Victoria. Is there something specific to Victoria here?
Yeah, so these cases actually come up a lot in Victoria, and it's often referred to as the suppression order capital of the country.
Why?
Well, according to analysis done by The Age, in 2023, Victorian courts issued 521 suppression orders. Just to put that into context, that's almost equal to the total number of suppression orders issued across the entire country.
That is crazy. Why is it so high?
So I actually reached out to a lawyer to try to find out the answer about this. His name's Justin Quill. He's from the firm Thompson Greer. And in the past 28 years, he says he's challenged more suppression orders than any other lawyer in the state. And he's done so mainly on behalf of media organizations who are arguing that the information in these cases is in the public interest. So he has some ideas about why these rates are so high in Victoria, and this is what he said.
My theory, the so-called gangland war, Tony Mockbell, Carl Williamson, all sorts of crooked cops and other crooks basically shooting each other. And they were involved in drug cases. So there were all these overlapping cases, like unprecedented at the time. And there probably was a reason for an increased number of suppression orders at the time. And I think, frankly, what happened is that that became almost the norm in Victoria. Judges and barristers almost became, if you like, conditioned to suppression orders.
Okay, so we have this precedent set during the gangland wars in Melbourne in the 2000s, and that has made suppression orders much more common. Has the state government done anything to intervene?
Yeah, they have actually. So in 2013, the Victorian government passed a piece of legislation called the Open Courts Act, and it was designed to try and clamp down on suppression orders. They did that because Australia's judicial system is actually based on the principle of open justice. That's why any person can go into a courtroom. That's why the media can report publicly on court cases, because it's the idea that we're able to hold the court system to account. Now, suppression orders are supposed to be a rare exception to this rule, but as I said, they've kind of just been increasingly high over the past decade or so.
So that piece of legislation came in over a decade ago, but we've just gone through the stats and they're still so high. So why is it still so high?
Well, here's a working theory. This came from Justin as well, and he said that it boiled down to a key change in the wording of the legislation that allows suppression orders. So prior to 2013, you could apply to have a suppression order put in place if you believe there was a threat to your, quote, physical safety. Remember that. Now, the Open Courts Act changed that wording to just say safety, so removed the physical part. This meant anyone can now apply for a suppression order if they believe that public scrutiny could impact their mental well-being or their mental, quote, safety. Cut to 2025, and Justin actually told me that mental harm is the most prevalent reason being given in suppression orders in Victoria over the last few months. Now, that's not to say that there's not genuine concerns about people's mental health being heard before the courts, but you can imagine that it's pretty hard for a judge who has a psychiatrist before them to argue with that point.
Before we end, I want to go back to the original case, because one thing that is interesting, when we're talking about legislation that came in a decade ago, social media wasn't as prevalent as it is now. This case about the man in Melbourne, I've seen it all over social media, some from news publications who obviously abide by these laws, but then there is also user-generated content by people who perhaps don't necessarily know about all of these laws, don't even know what a suppression order is potentially. And then you have all of these comments. How does that work with the suppression order?
It's a really interesting point, and I think we have to remember that suppression orders were designed when the main place that people were getting their information was traditional media. They were pretty much only going to the news. So it's kind of hard for them to hold up in this modern climate. Something interesting in that, though, that I found out is that anyone who does make a comment or a post on social media actually becomes a publisher in the eyes of the law. What that means with this rape case that we're talking about is if you post on TikTok or you make a comment, you could be in breach of the suppression order that the court has issued at this given time. However, it would be quite hard for a judge to crack down on the everyday poster because they're not court reporters. It's unlikely they even know that the suppression order exists in the first place. In regards to this specific rape case that we've just been talking about, it's not done. We are still awaiting sentencing, which means that suppression order stays in place for the foreseeable future.
But it could potentially be lifted at some point.
Yes.
So interesting, such a crazy example of, how technology is moving so fast and legislation finds it hard to try to keep up with how fast technology is moving.
100%.
Elliot, thank you so much for taking us through that.
Thanks, Billi.
And thank you so much for listening to this episode of The Daily Aus. We'll be back this afternoon with your evening headlines, but until then, have a great day.